Alright guys, in this slideshow, we're going to finish up the last of our defenses. So what we have here are infancy, intoxication, and the defense of insanity. And then we're going to wrap it up with a short discussion on duress and necessity. So it sounds like a lot, but we'll be able to get through these pretty quickly. Some of them are pretty self-explanatory. And the first one that is pretty self-explanatory is the defense of infancy. And for infancy, guys, we have age ranges. So what we're looking at here is that traditionally children who were under the age of 7 were considered legally incapable of committing a crime. So if you were under the age of 7, you were not able to be a defendant. And again, this is sort of like statutory rape where we don't really look at like, were you really capable? I have a 7-year-old, and I can tell you that last year when he was 6, there were some things where he knew right from wrong. There were some he didn't, but there were definitely things that he knew he should not be doing. So we don't really look at the individual child under the traditional rule. We have a hard and fast rule. If you are under the age of 7, you are legally incapable of committing a crime, and therefore you could not be a defendant. If you were between the ages of 7 and 14, we had what we call a presumption. So we presume that they can't commit a crime, but if the prosecution shows evidence, that tends to show that they knew what they were doing, for example. So maybe you have a 13-year-old and you find letters that they wrote, or diary entries, or they had told their friends ahead of time about a crime that they were going to commit and they knew what they were doing was wrong. Then, even though they fell within this age range, we could overcome that presumption and we could put them on trial as a defendant. Pennsylvania, the infancy defense is what we call viable, and it's up to the prosecution to prove that it should not apply. So if you're an attorney and you have someone who is between the ages of 7 and 14 usually, it's going to be up to the prosecution to prove that they should not be a defendant. So you're going to come in as the defense and say, my client legally can't be a defendant, and then the prosecution bears the burden of proof. All right. The next one, guys, is intoxication. The general rule is that voluntary intoxication is not going to give you a defense. And the key word here, guys, is voluntary. If a defendant goes out and becomes intoxicated because they're drinking or they're doing drugs, and as a result they become intoxicated, then generally speaking, they can't use that as a defense. It can be a defense if it negates the specific intent required to commit a crime. So it could be like assault, where you are trying to threaten someone. It could be murder. If you're charged with assault with the intent to kill, for example, um, you can't form the intent to kill if you are past a certain point of intoxication. So while you might be on the hook for the assault, if you actually follow through with an attack, and I know I just said assault if it's a threat, because remember, we can use those terms sort of interchangeably. If you assault someone, if you attack someone with the intent to kill them, you have to be able to actually form that intent in order to be found guilty. Involuntary intoxication can provide you with a defense. So, for example, if you go somewhere and someone drugs you, maybe you are drinking juice and someone puts roofies in your drink. Or maybe you're taking a medication that was prescribed to you and it has some unintended side effects. So if you're taking something and you did not voluntarily become intoxicated, then you could use intoxication as a defense in a lot of cases. But generally speaking, you can't use voluntary intoxication as a defense, like I said, unless it negates a specific intent. Now let's go back to our example with Kermit. Okay, Kermit is charged with assault and intent to kill Miss Piggy. So he assaults her. He physically attacks her. All right. He is going to be guilty of the assault. Right? You can't just say, "Well, I was intoxicated, so I didn't mean to hit her," or whatever. What he won't be charged with is the intent to kill because he was too intoxicated to form that intent. Now, let's say he did follow through and as a result of the assault, she did die, he could still be charged with, depending on the exact circumstances, um, certain degree of manslaughter or murder. And again, that would depend on exactly what happened. But that's not going to provide you with a defense where you just sort of get away with whatever the crime was. All right, guys, the insanity defense, we looked at that a little bit already. People who have a mental disease should not be convicted of a crime if they don't know what they're doing or if they don't know right from wrong. And this is one of the oldest defenses that we have. It actually dates back to the ancient Greeks and Romans. If you look at different states, they do have different rules. And in Pennsylvania, as you guys all saw from your assignment the other day, we use what is called the McNaughton rule. And in order to prove that you are insane under the McNaughton rule, the burden of proof is on the defendant. Generally, in a criminal trial, the burden of proof will be on the prosecution, right? You're innocent until they prove that you're guilty. If they make their case and show that you're guilty and you want to present the insanity defense, you have to prove that you're insane. In other words, it's not up to them to prove you're not insane on top of proving that you committed the crime. Now, of course, they're going to offer evidence to prove that you're not insane. But if you want to establish that defense, you have to prove it. All right, so what exactly is the McNaughton rule? Well, we look at two things here, and the first is, did the defendant know that what he was doing was wrong? All right. So in our example, a man murders his wife, waits calmly for police to arrive. It was determined that the man was mentally ill and didn't realize that killing his wife was wrong. And we see this sometimes, guys, when someone commits a crime and we look at it and we think, how could they not know that that was a bad thing? Sometimes this comes up with parents who are mentally ill and kill their children. And we see this sometimes with women who have postpartum depression, which sort of a temporary type of mental illness, if you will. And you think, you hear of like a woman who, and I use woman because with the postpartum, it's the hormones from birth, so the men don't have that. Maybe kills her children and then thinks that she was actually doing something good for them. They were, in danger here, or something bad was going to happen to them if they stayed alive, so she killed them to protect them. And that would fall under the McNaughton rule because they did not know at the time of the crime that what they did was wrong. Second question is, did the defendant know what he was doing? Did they even know that they were killing someone? And this, everyone always chuckles when I use this example. This was actually from a real case. A woman with mental illness kills her neighbor by beating him with a shovel, then claims she killed a demon sent to harvest her soul. Right? So she believed that she was killing a demon. She did not realize that she was killing her neighbor. So she didn't know what she was doing. When I was in middle school, we learned about mental health and some of these things like that. For some reason, this example always sticks with me. 8th grade, I'm not going to even tell you how many years ago that was. It's quite a long time, you guys. But I very specifically remember the health teacher telling us a story of a woman who killed her neighbor because she thought that she was a glass of orange juice and her neighbor was trying to drink her. For some reason, as a 13-year-old or 14-year-old, we all thought that was funny. As an adult now, I realize, wow, that's pretty terrible that we thought that was funny. But in that case, guys, she would have been found to be insane under the McNaughton rule because she did not know what she was doing. She thought she was killing someone that was going to drink her. She didn't realize that she was not, in fact, a glass of juice. The key here, guys, is this applies if the defendant was insane at the time of the crime. So if you have someone that has mental illness and they take their medication and then they stop and they commit a crime while they are not on their medication and they are suffering under what we call an insane delusion, if they go home, take their medication, and then they're perfectly fine, and they go into trial, prosecution can't point at them and say, look at this person. They're fine. They're medicated. We've not seen any insane outbursts from them, right? What we're going to look at, guys, is, was the person suffering under an insane delusion at the time of the crime. The flip side of that, guys, you have someone that's perfectly fine. Maybe they do take medication and they commit a crime. You can't like go off your medication in order to try to provide yourself with an insanity defense. That's not going to work because, again, they're going to look at the state you were in at the time the crime was committed. Okay, and the last two guys are duress and necessity, and these are very closely related, but they are different. Duress is when you have a defendant who has to do something as a result of coercion or threat of immediate danger to life or personal safety, not property damage. So if someone holds a gun to you and says, you need to go into the store and steal a pack of gum or else I'm going to shoot you, right? If you go into the store, you steal a pack of gum and you get caught, you can use duress as a defense. You are in immediate danger to your own life. If they say, listen, go into the store and steal a pack of gum, or I'm going to smash in the windshield of your car, that doesn't count. All right. What we're going to look at here is, were you under a threat that actually made it so that you could not exercise your own free will? Guys, duress is not a defense to homicide. In other words, we're not going to trade one person's life for another. So if you have a defendant and they say, well, yeah, I killed person A because this other person held a gun to my head and said, either you shoot them or I'll shoot you. And I do get a lot of pushback on this a lot. Kids are like, well, if it's my life or someone else's, of course I'm going to do whatever I can to save myself. I'm not going to argue with that. I'm not going to tell you what I would do in that situation because it's irrelevant. This is what the law says. If you kill someone, you cannot use duress as a defense. All right. The same rule applies to necessity, which is a little bit different. Necessity, if you think all the way back to the beginning of the semester when we talked about the guys in the boat who, the boat sinks and they're in the life raft, and then after so many days they kill one of their shipmates and eat him. All right. So necessity is when an individual acts when he or she is compelled to react to a situation that is unavoidable. So that's key one. It has to be something that is unavoidable. And you have to be protecting your life. Again, we're not interested in protecting our property here. We're interested in protecting our life. Now, they argued necessity there or some variation of it, but the court said, nope, you can't do it. And the same rule applies in the United States. If you'll recall, that case was in England, I think it was. You cannot use this as a defense to homicide. All right. So if our sailors are adrift in a lifeboat and the lifeboat is sinking because it's full of cargo, and they throw the cargo overboard and destroy the property, when they are rescued, the owner of the property then sues them, or not sues them. That's a different story. Right? If they try to have them arrested for destruction of property, they can use necessity as a defense. If you are walking down the road and you see a tornado in the distance, I don't know why you'd be out walking if there's a tornado coming, but let's say you are, all right? If you break into a nearby house or a nearby business in order to take shelter, that can be necessity, right? It's trespass, it's illegal, but you needed to do it because this tornado that's coming towards you was unavoidable and you need to protect your life. So duress and necessity are very similar in that you are reacting in order to avoid harm to yourself. But with duress, it's usually something that someone else did or created, right? Someone else is threatening you. With necessity, it's usually more of a natural type of thing. There is severe weather coming. The boat sank, something like that. So that's usually the difference. And again, neither one of these defenses can apply when we're talking about homicide. All right, guys, that's it for the defenses. Please make sure you understand these. And again, unless I've specifically noted otherwise, like here with the homicide defense, these generally can be applied to any of the crimes that we've talked about. As always, if you have questions, send me an email or let me know in the comments. Have a good one, guys.